Many cannabis-related legal problems in Virginia do not happen because someone intended to break the law. They happen because people rely on myths, half-truths, or outdated information. Today, we are breaking down the most common Virginia cannabis law myths that quietly lead people into legal trouble, often when they least expect it. Here's the context. Virginia's cannabis laws are often described as confusing, and that description is accurate. The state has decriminalized certain conduct, allowed limited adult possession, created a medical cannabis program, and at the same time maintained strict enforcement authority for police and local governments. This mix creates a dangerous gap between what people think the law allows and how the law is actually enforced. In this video, we are focusing strictly on Virginia cannabis law as written and applied, with special attention to Norfolk and the Hampton Roads region. This is legal education, not advocacy, and not lifestyle content. Myth 1: Possession means full legal protection. One of the most widespread myths is that possession of cannabis is fully legal in Virginia. The reality is more limited. Virginia allows adults to possess cannabis up to a defined amount, but that allowance does not eliminate legal risk. Possession becomes unlawful when quantity limits are exceeded, when cannabis is possessed in prohibited locations, or when other violations occur at the same time. Even small amounts can lead to citations or charges depending on the circumstances. Another overlooked detail is that legal possession does not prevent law enforcement from conducting investigations. Officers may still question, detain, or cite individuals when cannabis is present, particularly during traffic stops or public encounters. Myth 2: Transportation rules do not matter. Many people believe that if possession is legal, transportation rules no longer apply. This myth causes significant legal trouble across Virginia. Virginia law places restrictions on how cannabis may be transported in a vehicle. Cannabis that is accessible to the driver can create legal exposure. During traffic stops, law enforcement frequently treats accessible cannabis as a violation even when possession limits are not exceeded. In practice, transportation issues are one of the most common ways cannabis-related charges arise. These situations often escalate from minor traffic violations into legal matters that require court appearances. Myth 3: Public use is allowed. Another common misunderstanding is the belief that cannabis use is permitted in public spaces. In Virginia, public use remains prohibited. Public spaces include sidewalks, parks, beaches, parking lots, and many shared residential areas. Local ordinances and state law both play a role in enforcement. In cities like Norfolk, public use citations remain common. Public use violations often lead to secondary issues, including disorderly conduct citations or increased scrutiny from law enforcement. What may feel like a minor act can quickly become a documented legal issue. Myth 4: Medical cannabis overrides all restrictions. Medical cannabis patients often assume that holding a medical cannabis card provides broad legal protection. This is not the case. Virginia's medical cannabis program includes specific rules regarding possession amounts, approved product forms, and use locations. Patients must still comply with transportation rules and public use restrictions. Additionally, medical cannabis authorization does not override federal restrictions, workplace policies, or housing rules. Patients who misunderstand these limits often face consequences unrelated to criminal law, such as employment or lease violations. Myth 5: Local governments no longer enforce cannabis laws. Some people believe that local enforcement has ended or that police departments no longer prioritize cannabis-related issues. This is incorrect. Local governments across Virginia, including Norfolk and other Hampton Roads jurisdictions, retain enforcement authority. Police continue to enforce state law, local ordinances, zoning rules, and public conduct regulations. Local enforcement patterns vary, but enforcement has not disappeared. In some cases, cannabis-related issues are used as secondary charges during unrelated investigations. Scenario: Consider this scenario. A Norfolk resident believes cannabis possession is fully legal and keeps a small container in their vehicle's center console. During a routine traffic stop for a broken tail light, the officer notices the container within reach of the driver. Although the amount is under the legal limit, the accessibility creates a transportation issue. The situation escalates into a citation and a court date. What began as a minor traffic stop becomes a lasting legal record. Who this affects? These myths affect a wide range of people. Working adults who assume cannabis laws mirror other states. Medical patients who misunderstand program limits. Renters who are unaware of housing restrictions. Visitors who rely on outdated information. Cannabis-related citations can affect background checks, professional licensing, security clearances, and employment opportunities. The impact often extends far beyond the initial encounter. Why this matters? Understanding Virginia cannabis law is about risk management, not personal opinions. Even minor violations can result in fines, court appearances, and permanent records. Legal trouble also carries hidden costs, including legal fees, lost work time, and stress. Clear information helps individuals protect themselves and helps communities reduce misinformation-driven harm. What to watch next? In future videos, we will examine how Virginia zoning laws affect cannabis enforcement, how courts interpret cannabis-related cases, and how medical cannabis regulations differ from adult possession rules. Question: which Virginia cannabis law myth do you encounter most often, and why do you think it continues to spread? Put your answer in the comments below. Please like, comment, and subscribe for more videos like this.